Well, hello everyone, and thank you for joining me today. We are going to be talking about Medicaid benefits with no spend down, and that is how married couples can get the state to pay for their long-term care without having to spend down all of their money. So it is a really fun and interesting topic, Medicaid asset preservation strategies. I'm excited to talk with you about them today because this is information that people simply don't know about. So my name is Lynn St. and I am an estate planning and elder law attorney at ELG Estate Planning. We practice in Washington and in Idaho. And one of the core areas of our practice is Medicaid asset preservation strategies. And what that is a knowledge of what Medicaid's rules are so that we can help our clients protect and preserve their money using Medicaid's rules and obtain benefits without having to become impoverished. So as many of you probably believe, understandably so, Medicaid is called an impoverishment program. And frankly, for single people, it is. Medicaid only allows $2,000 in countable assets for a single person. Now, there's a bunch of exceptions to the rules and what's countable, what's not countable. We'll be talking about those. But today, my goal is to help you understand more about the Medicaid program so that if you, your spouse, a family member, or somebody you know in the community, if they are facing long-term care, that they will be able to take some steps to protect themselves so that they don't end up having to spend all of their money and go broke, because typically that is what happens. I'm going to be explaining with a story of a couple so that you can see how we implement the strategy and just one example. But before I do that, I want to do a really brief explanation about Medicaid program. If you have any questions, just go ahead and put them into the chat. All right, so Medicaid is different than Medicare. If you are over the age of 65, you've signed up for Medicare, that likely is your health insurance program. You pay a premium and you get Medicare coverage. Medicaid is a needs-based program. It is not something that you are able to get unless you qualify from an income and a resource perspective for the benefits it provides. Medicare does not pay for long-term care. Medicaid is the government benefit program that pays for long-term care. Now, you might be saying, but I know somebody who went to the hospital, they broke their hip, they went to rehab, and Medicare did pay for that rehab in the rehab facility. And it paid at least a portion of it for up to 100 days. That is true. Medicare does pay for rehabilitation, but there is a cutoff, and typically it is 100 days, if not less than that. So if the person who's been in the rehab facility hits that 100 days and they can't go home, what do they do? Medicare is no longer going to pay for that care in the facility. Medicaid would be the government benefit program that does. What do people typically do? They typically just say, oh, well, this is going to cost a lot of money, because they don't know that there are steps that they can take to get the state to pay for the care through the Medicaid program. So Medicaid is a state and federally funded program. Every state has its own set of rules. So what I'm going to be talking about today is Washington's rules on Medicaid. If you live in a different state, be aware that what I'm talking about won't apply to your state necessarily. If you are in a different state and you're interested in Medicaid strategies, you should talk to an elder law attorney in that state. How do you find an elder law attorney? the National Academy of Elder Law Attorneys is the best resource to find an elder law attorney in whatever state where the care will be provided. How many of you have heard Medicaid has a 5-year look back? A lot of people have. That is true. Used to be a 3-year look back way back when. Now it's a 5-year look back. What does that mean? That means you cannot give away resources within 5 years of an application for benefits, because if you do that, the state reasonably says you gave away money. Why would we pay for your care if you gave away your assets? That's the 5-year rule. And under the 5-year rule, the standard is, I'm going to be using some numbers here, and I apologize, but for every $10,785 you give away, there's a 1-month period of ineligibility, a penalty period where you don't get Medicaid. Now, these are the basic rules. These are not rules that necessarily will apply between spouses, or they won't apply between spouses. The reason for that is that the state looks at both people in that married couple, and they say, okay, couple, here's what your resources are. So the state doesn't apply a transfer penalty between spouses. So the Medicaid 5-year look back does not apply as to what spouses do with their assets between themselves. So that's really an important distinction and something important to understand about Medicaid's 5-year look back rule. Typically, the 5-year look back rule applies to when a couple gives assets away out of the marital community to somebody else. So that's an important rule to understand. The state also has a policy against what they call spousal impoverishment. So really what that means is the state does not want to see the well spouse. In a couple, there's going to be an ill spouse, the person who needs long-term care, and there's going to be a well spouse, the person who doesn't. The state has a policy against impoverishing the well spouse. So unlike a single person who can only have $2,000, where a couple is involved, the Medicaid spouse, the ill spouse, can only have $2,000 in countable resources, but the well spouse can have between $59,890 and $137,400. So these are not numbers I make up. These are the standards that the state has in place. And for those of you attending today, we're going to be sending you this information so that you have it to take a look at yourself. So it's a really good thing that the state has this community spousal resource allowance so that the well spouse doesn't have to become impoverished. It is because of that and because of some other rules that an elder law attorney knows about that we can have the ill spouse go on Medicaid and the well spouse keep all their money without a spend down. So let's get into an example, because I think the example is the best way for you to see what I'm talking about and how this particular strategy works to avoid a spend down. So let's take a couple, Mary and Mark, and they're both retired, and Mark has a stroke. And Mark goes to the hospital, and from the hospital, he goes into rehab. But toward the end of his rehab, it becomes quite clear that he is not going to be able to go home. Mary is 80 years old. She cannot take care of her husband, Mark, at home with the effects of the stroke, with paralysis, with his immobility, with all the sorts of things that we are aware of that can happen from a stroke. So even though he's recovered somewhat from the stroke, he hasn't recovered his mobility, he He hasn't recovered to independence. So what that means is that Mary needs to find a long-term care facility to take care of her husband, because frankly, she just can't do so. And this is a very, very common situation. What's the biggest problem that this couple is facing? The skilled nursing facility that Mark needs to move to costs $12,000 per month. That's $144,000 per year. For some people that have sufficient wealth, they can pay for it. For the majority of people, the majority of clients that we work with, that we see, is that just the thought of paying $12,000 a month of what they've worked so hard to put away is going to be devastating financially to them. Maybe there'll be enough money to pay for Mark's care, but what's going to happen after he passes and Mary needs care? And this, frankly, is something that commonly happens, is that the couple looks at it and they go, well, we can pay for this, but they do, or they try to, but they leave Mary with no money at the end of the day. And that does not have to happen. So what can they do? Well, let me give you some more facts about their resources. As I recall, I said that Medicaid has resource limits. So for Mary and Mark, they own their home. It's worth $300,000, probably more now, but they both have retirement accounts. And Mark has $150,000 in his Roth IRA. Mary has $100,000 in her 403B. So, and then in addition to that, they have $200,000 in a stock portfolio, in investments, and $50,000 in a checking account. Clearly, this couple has way more than the $137,000 that Medicaid says they can keep. What do? They see an elder law attorney, and we come up with a Medicaid asset preservation strategy, and it is as follows. So we are going to make sure that Mary is going to be able to keep that maximum amount of $137,400 in countable resources. But I didn't do the math and added up everything for you. But what I want you to know is, with all those numbers I gave you, with the Roth IRA of $150,000, with Mary's 403B of $100,000, with a $200,000 investment account and $50,000 in the bank, even though Mary is allowed to keep $137,400, if we do the math, they still have $360,600 too much money. What are they going to do? What do most people do? They spend it down. What do people do who come to a Medicaid attorney, a planning attorney, such as ELG Estate Planning? We're going to look at what's the best use of this money, and then what they don't need. We are going to use a tool that's called a Medicaid compliant annuity. I'm going to talk about that. So I remember I said they have a house, it's worth $300,000. They do. That house is a non-countable resource. It could be worth $400,000, $500,000, $1 million. The house is non-countable for a couple, regardless of its value. So the house for a couple, it's not countable. We don't put it in the equation about what resources have to be spent down, what can they keep. They can keep it. However, because Mark is going to be going on Medicaid, we want to ensure that Mark's name is not on that house, because if it is, when he passes, the state will have a lien on that house. We can avoid that lien easily by Mark doing a quit claim deed to Mary. Now Mary owns the house in her name. Mark has no interest. We typically do what's called a separate property agreement as well, where Mark says, I don't own anything, everything is Mary's. By putting everything in Mary's name, the state won't have a lien on any of their assets. But I get ahead of myself. I'm talking about a lien, And I haven't yet shown you how Mark is going to get on Medicaid. So let me keep going. So Mary thinks, well, I want to use some of this money to do some improvements around the house. You know, maybe she needs a new roof. Maybe she wants something for the kitchen. Maybe there's just a few things she's been putting off because they're frugal and they don't like to spend money. So she does those things that she's been putting off, but we're not talking about a whole lot of money. You might have her spend down, I don't know, $10,000, whatever she needs to encourage her to make her home more livable for herself, because she's going to be living there now on her own. Then she can buy some other things that aren't countable. We really recommend that clients look into burial plans. She can spend money on an irrevocable or cremation or burial plan. Maybe she takes $6,000 to make sure that she and her husband both will have a plan in place. That's a really good idea to spend money on that. Now, it should be irrevocable. If it's irrevocable, the state doesn't count it as an asset. So that's a good plan. And then she's probably going to look at, does her car, should she replace it? She's driving a 2002 Camry, for example. So maybe she's going to take some money and trade in the old car and buy a new car so she doesn't have to worry about her car not working. These are all just ideas. They're not something that necessarily have to be done. I'm just sharing with you the thinking about, well, what would be a good use of our money? And when I say a good use of our money, I'm not saying they have to spend down on the facility. I'm saying, let's be smart. Let's get your life set up so as you are going through your life, Mary, and Mark is in the facility, your life is better. Maybe a new car would help so that you can have reliable transportation there. So the big piece of a Medicaid strategy, though, that avoids spend down is what I had mentioned earlier. It's called a Medicaid compliant annuity. How does that work? The money that is above the $137,400, that extra money, remember I said it was like $360,000 and then she did a little bit of spend down. She did some spend down on various things. Let's say when she's done all that, buying a car, buying whatever she needs for a house, etc., buying that burial plan, she still has $324,000 too much. That's a lot of money to have too much money. Don't spend it down. Take that money and she buys an annuity. I said it was a Medicaid compliant annuity. What I mean by that is this is not the kind of annuity that anybody here listening to me has today, unless they are on Medicaid or their spouse is on Medicaid. You would never buy this annuity unless you're doing it for the sole purpose of Medicaid benefits. Why do we buy this annuity? Because taking the extra $324,000 in my example and having Mary buy an annuity means that she took countable resources, cash, and made it non-countable, because the annuity is non-countable. So you can take that money and buy this annuity that the state allows you to buy and not spend it down. So you're going to be saying, what's the catch? There's a catch. And here's what the catch is. The state requires that this annuity pay back to Mary over the next 60 months or 5 years. Sounds good. She's going to get all of her money back. She doesn't have to spend that $324,000. She's going to get it back. But what if Mary dies during that 60-month term? Then where does the money go? It does not go to their kids. If Mary dies during the term of the 60-month annuity, then the state is the beneficiary for the next payments that are coming out of that annuity. How much does the state get? The measuring point for how much the state gets is how much did they pay for Mark as of the date of Mary's death? Let's say they paid $100,000 for Mark's benefits. then the state gets the next $100,000 paid month by month by month by month from that annuity. All right, so let's say there's still more money left. The state's been paid back their $100,000. Mark's still on Medicaid. There's still annuity paying out money each month. Then the kids can get that remainder payments. So the annuity, the catch to the annuity is the state says, if you, spouse, don't survive the 5 years, then we get the next payments from the annuity, which frankly doesn't seem unfair, in that the state is not kicking Mark off of Medicaid. They're just saying, we allowed him to get on. We allowed you, Mary, to keep all your money, even through an annuity. And if you don't need that money because you've died, the community spousal resource allowance, we don't need that anymore. We're going to get the next payments. So that's how that annuity works. That is probably the most effective tool for couples to use while they're both alive and while one of them needs care, especially high cost care like skilled nursing care, which can run, $12,000 a month every month for the rest of that person's life. So I didn't do the math for you on the annuity. If Mary were to put $324,000 into that annuity, she gets back over the next 60 months, assuming she lives through the next 60 months, $5,400 per month. Okay, $5,400 per month. That is not contributed to Mark's care. Mary's income is not contributed to Mark's care. All that goes to Mark's care costs are his income, and the state pays the rest. Mary gets to keep all of that money, the house, everything as it pays back to her. Now, when we filed the Medicaid application, we had to show that this couple was within resource limits. We had to show that they had no more than the $137,400 in countable assets. We showed that. Here's a bank account. Here's this Medicaid compliant annuity. Yes, it has over $300,000 in it, but they don't count that. Mark is on Medicaid. The state pays for his care. But I mentioned this annuity is paying back to Mary at $5,400 every month. She's not paying for Mark's care. What's going on? Her resources are climbing back up where they used to be. Every month they increase. Is that a problem with the state? It is not a problem. The state measures the couple's resource only once. That's at the financial snapshot date. So Mary's resources can climb back up, and that doesn't impact Mark's Medicaid eligibility. The only thing that impacts his eligibility is that he can have no more than $2,000. So what happens if somehow Mark gets more than $2,000? He just transfers it over to his spouse, not a problem. But at the eligibility review, at the 12-month anniversary after Mark goes on Medicaid, it's important that he only have $2,000 in his bank account, and that's all that he has. So this is probably the most effective strategy that exists to have a couple use Medicaid benefits without getting rid of their money, without spending it down. They purchased a Medicaid compliant annuity, and Mary got to keep all of her money. Before I move on, I just want to make sure we don't have any questions about that, because frankly, usually people go, really? Why does Medicaid allow that? How does that work? It's because of the community spousal policy against impoverishing the spouse, and the Medicaid annuity is something that we have had for many years, and it is something that we only recommend to the clients that they get at the time of need. Because of that payback to the state, it would make no sense to buy it before the time of need. So a couple of questions here. Yes. So when Mark is on Medicaid, he should have his own bank account into which his income pays. Mary's name can be on it. Everything else is going to be in Mary's name. She's going to have her own bank accounts, investment accounts, all of that. Everything is going to be in her name, including the car, the house, the investment. Everything is going to be in her name. And Mary's name should be on that account that has Mark's name on it. But the only activity in that account is his income is going to pay into it, and his income is going to be, then Mary needs to write a check to pay the facility for what's called Mark's participation. His income must go to the facility. He gets to keep for his own personal needs allowance about $75, not much. So there should not be joint accounts. Everything should be in the well spouse's name, except for this one account that's in the ill spouse's name that the income pays in. Let's say the income is not just Social Security, but let's say Mark gets a pension as well. That pension is income. Income must be paid or participated to the care facility. So a pension, which is a flow of income like Social Security is, that pays every month, is income that has to go to the facility. Be careful when we're talking about, pension versus retirement and such. Anything that can be cashed in has to be cashed in. So let's say Mark really didn't have a pension. What he had was, some other form of a retirement account, like a $100,000 Roth, for example. He had to take that Roth and he had to put it in Mary's name. And the good thing about my example is that it was a Roth, so there's no tax consequences for him doing that. So income of Mark's must pay to the facility. Can a person buy the annuity when something happens to the spouse? Yes. Same question about the deed on the house. That's a great question. So, and a related question is, what if Mark's stroke has left him so that he can't communicate, he doesn't have legal capacity, or any of these issues? Can the strategy that I just explained to you be implemented or not? The answer depends on their estate planning documents. So if Mark and Mary went to an elder law attorney and they had their estate plan done while they were both well, but they were both wanted to make sure that they provide for each other and have everything in place that they might need in case something happened, then the strategy can be done. On the other hand, if Mark and Mary don't have an estate plan, or they have an estate plan, but it is one that doesn't include certain provisions, it's very difficult to do the strategy. So let me explain what I mean. So when we do an estate plan for clients, we make sure that their durable powers of attorney include certain authorizations, such as the authorization to revoke a community property agreement, to enter into a separate property agreement, to do any kind of deeds on the house, to change beneficiary designations on accounts, to liquidate any accounts, to gift. Now, nothing here involved gifting for Medicaid, but sometimes gifting for Medicaid is part of the strategy. And we want to have the ability to do whatever is best for this couple and not have our hands tied. So oftentimes when we are working with clients in a Medicaid situation, they come to us with estate planning documents that were prepared by a non-elder law attorney, and we don't have the ability to do much of what I have described. So our hands are tied. So if Mark and Mary don't have good durable powers of attorney, it may be difficult to implement this plan. I'm not going to say impossible, but I'm going to say difficult. We try to be as creative as we can with our strategies, but frankly, if there's a community property agreement, we call it a 3-pronged community property agreement, or if there's a joint durable power of attorney that says you can't change anything, you can't do anything, really there's nothing we can do. Our hands are tied and this couple has to spend down their money, and that's really unfortunate. And it could be an old document, usually when we see this, they're old, 10, 15, 20 years ago. Newer documents, we often find that there's some deficiencies in them if it was done either by a general practitioner or somebody, even an estate planning lawyer that doesn't understand Medicaid's rules. And when it comes to Medicaid rules, Medicaid benefits, it's no surprise you'll find that it is a very specialized area of practice. It's an area of practice that people don't dabble in because the consequences of dabbling are pretty severe. So you really want to reach out to somebody who can say, this is what we do. We focus on this. We specialize in this. We have 30 Medicaid cases open right now, applications pending now. You just don't want to go to an attorney who doesn't have that level of expertise. And frankly, when it comes to doing your estate planning documents, we think it's really important that whomever does the estate planning at least understands Medicaid's rules enough to incorporate into the documents the durable powers of attorney, the necessary provisions and authority to do a Medicaid strategy, like I've explained. A question about estate planning, and I'll get to wills as well, because we're talking about two people who are alive, but we can't forget what happens if one of this couple dies. But before I get there, there's a question: what if everything is currently in a revocable living trust? The state has this unique rule that if your house is in a revocable living trust, it is a countable resource. If your house is owned in your own name, it's non-countable. It is definitely form over substance. So what we have to do when a house is in a revocable living trust and we do a Medicaid strategy is we have to take it out. We move the house out of the trust into the name of the well spouse, and we hope that the terms of the revocable living trust allow us to do that. So Medicaid's rules, a lot of them, well, I can't say a lot of them make sense, but a lot of them don't make sense. And the fact that a house in a revocable living trust is countable, and if it's not in the trust is non-countable, is one of those you just shake your head. That's just how it is. What about the rest of their estate planning documents? So we have all the assets in Mary's name. Mark's on Medicaid. We did that so that Mark could have his care paid for by the state, what his income doesn't cover. Mary gets to keep all of her money. The state will never have a lien on the assets because none of them are in Mark's name. And then what if Mary dies first? That could be a big problem. I explained to you what happens if Mary dies within the 5 years. The state gets the next payments on that annuity. But how about the house and the investment accounts and everything else? There is a solution to what could be a really bad problem. The really bad problem is Mary doesn't have the right kind of a will. Mary has some will that says, on my death, everything goes to my spouse. Well, if that were to happen, then Mark is the owner of all of these assets. He is immediately bumped off of Medicaid, and without any other strategies that we might be able to help with, he has to spend down all of his money, and then the house goes to the state. It's a terrible result. It can be easily avoided by Mary having a will that contains an asset protection supplemental needs trust. What is that? What does that mean? Remember, Mary has all the assets in her name. If she happens to die first, we want all of those assets to go into a trust for Mark. This trust must be in her will. It cannot be created through a revocable living trust. It has to be a trust that Mary's will creates for Mark. The type of a trust, it's called a supplemental needs trust. Why it protects assets is a discretionary trust. What that means is that Mark cannot compel distributions or Mark's attorney in fact, or anybody or the state. Nobody can say that the assets in the trust must be paid for Mark's care. What that means is that they are shielded and protected from any spend down. Mark stays on Medicaid potentially there's, 500, 600, however many thousands, hundreds of thousands of dollars in this trust. And Mark stays on Medicaid because Mary did the right kind of will, one with this special trust in it. Mark can't be the trustee, plus he has, let's say, a stroke or other cognitive problems anyway. One of the kids likely is going to be the trustee. They use that money in the trust for whatever might make Mark's life better, but they don't and won't use that money to pay for his care. Then when Mark dies, state has no lien, Medicaid gets no recovery, and all of that money in the trust goes to wherever Mark and Mary said they wanted it to go. Let's assume they have 2 kids. It goes down to the 2 kids equally, for example, with not much work. It's basically the trustee liquidates the assets and distributes them out to the remainder beneficiaries. All of this being said is there are very effective Medicaid strategies, and they can work without having the good estate planning documents in place, as long as both people in the couple have good capacity, good legal ability to do what they need to do. That's a major risk, because one of the reasons that we do planning for future Medicaid benefits is we all know that disabilities happen, dementia, Alzheimer's, Parkinson's, strokes, heart attacks. The list goes on, and I'll stop because everybody knows that. So we want to do estate planning in advance because we want to make sure that the couple has whatever they need to protect their assets for the benefit of both spouses, and to make sure that no matter what, no one in this couple is going to be impoverished, and benefit to the remainder men, be there the kids or whomever. There likely will be money left when both of this couple have passed. Tell me, does it all make sense, or is this like, I see some okay, it's making some sense. Good. I'm happy to answer more questions about the couple. If I don't see any more questions, what I'm going to do is I'm going to go into a little bit more detail about Medicaid's rules for you. Would it be prudent to start giving assets to the kids? It all depends. Usually people start thinking about giving assets to the kids when Medicaid is less, or when long-term care is less than 5 years out. But let's say you're younger and you're saying, there's another good strategy, is use the 5-year look-back rule to your advantage. There's some really good reasons to do that. So let's say you have that legacy property at Priest Lake, and the kids are going to be able to afford it, or even if they're not, you're going to give them not just the lake place, but some money so that they can pay those property taxes and maintenance costs on it, right? So with legacy property, yes, you can give it away 5 years in advance. Now, I'm using the term legacy property because how I'm using that is we don't expect that lake place will be sold. If it's sold, we're going to run into some capital gains tax issues that might suggest you shouldn't give it away, because it's advantageous to inherit property. It gets an adjustment in tax basis, a step up in tax basis, so that if that property is sold, there's no capital gains. But you're not worried about capital gains. So you're fine with giving away the property. It has the same tax basis that it had when you bought it or when you got it from your parents, etc., because it's going to stay in the family forever. So you can give it away. You can give it away to a limited liability company, a family limited liability company that you create for the benefit of the kids. You can give it away to an irrevocable trust for the benefit of the kids. You can do any of that makes sense. And you just can't retain a right to be the owner of the property. Well, you gave it away. And you don't want to retain the right even to have use of the property because you've retained a beneficial interest, and that pulls it back into your estate for Medicaid's purposes. But absolutely, there's some very good reasons to give away property 5 years in advance of needing Medicaid. But what I would say is make sure you sit down with your estate planning lawyer and talk through whether it's a good idea or whether it's a bad idea. And lots of times it's tax considerations and other things that you're not thinking about. If you're talking about just like giving away money, possibly. I usually discourage clients from giving away money depending on how much money they have. Frankly, if you have, more than $1 million in liquidity or $2 million in liquidity, these Medicaid strategies are not likely appropriate for you. Because if you I didn't mention, but with a Medicaid compliant annuity, it doesn't have an interest rate return. You're not increasing the amount of the money you've invested. But if you had $1 million and you have a good financial advisor, and let's say they're returning 8% a year, that's $80,000 a year. It might just be smarter to use your money, have it work for you with your financial advisor, and never even think about Medicaid. So whether Medicaid and Medicaid strategies and spend down and annuities is appropriate really in large part is dependent on your asset level, the care needs and costs, the age of the person, whether or not we're looking at a 10-year long-term care event or maybe a 2-month long-term care event. Obviously, the more expensive the care, the longer the life expectancy of the person in care, the more likely we're going to recommend a Medicaid strategy. Whereas if it's, 2 months and hospice is called in, we're not likely to recommend anything with regard to Medicaid. So everybody's situation is different. Question. What we were talking about with this Medicaid strategy only applies if you are a married person or a registered domestic partner. It does not apply to what is called a committed intimate relationship, a life partner, anything that doesn't have any legal stamp associated with it. So all these strategies are what we talk about with married people or registered domestic partners. A single person has much more limited options for qualifying for Medicaid. Single people can only have $2,000. They can have their house, and now the house equity limit used to be about $700,000. It's gone up to about $950,000 now. That came out of King County for the most part, the increase, by the way, which is great for single people. But remember, if a single person gets on Medicaid, they had $2,000 in their account, they still own their $900,000 house, the state's going to have a lien, probably enough equity in it that some of it will go to the kids. But there are a lot of exceptions to Medicaid's rules. For example, you can give away assets with no penalty to your disabled child. However, if you do that, make sure your disabled child, if they receive money, isn't going to be kicked off their benefits. If they are, then we have to do a Medicaid trust so that they can receive your money, you go on Medicaid, they get the money, and they still get their benefits. But you should be aware that there is an exemption to the you can't give away money rule. You can to disabled children. You can even give them your house. To disabled people, you can give them your assets. If you are the caregiver child, you've lived with your parent in their house for 2 years and you provided care, and then they need to go on Medicaid and they go straight away to Medicaid with no private pay, you can have the house transferred to you if you meet all the dot your I's and cross your T's. It can be done. One of the problems with that caregiver child transfer rule is that even though skilled nursing facilities don't have a private pay requirement for the most part, assisted living and adult family homes often have a 2 to 3 year private pay requirement. And what that means is the caregiver child transfer rule won't be available because there can be no private pay for that exemption to work. Those are the main exemptions. I'm sure I forgot to cover one or more. So if anybody is interested in their own situation, feel free to reach out and contact us. You know, these webinars aren't legal advice to you directly. I can't give you legal advice through this forum. Obviously, the only way we can do that is if we really meet with somebody and our services are engaged, and then we can help you and give you your, you know, a plan that works for you given what your situation is. But my goal really is to share this information and to open your mind to that there are more possibilities maybe than what you thought there were, what you believe there are, especially if there's anybody you know, and this happens so often, that, you know, people are just spending down their money, they're selling their house. There's so many things that I'd say, stop, don't sell your house, don't spend down your money. See, you know, a qualified elder law attorney first, because there may be many things that we can help with, including protecting and preserving those assets. So in terms of, you know, reaching out to us, our phone number is there. It's 509-468-0551. We're going to be reaching out to you and giving you this scenario I gave you with Mark and Mary so that you can see it in front of you. The conditions that we were just talking about, I gave you a Washington example. I didn't give you an example for other states. Idaho, we're licensed in Idaho as well. Their Medicaid rules are significantly different. They do allow Medicaid compliant annuities, but there's some resources they don't count. They have different income limits that we have. So in terms of what we're talking about today, I'm only discussing Washington's law. In terms of, you know, how our services work, we typically, for, you know, various kinds of consultations, may offer them complimentary. For other ones dealing with Medicaid, we usually charge a fee for the Medicaid consultation. Whatever the situation is, we want to make sure that you understand what we might recommend before there's ever an agreement that you're retaining us or that we're working for you. So we think it's really important that people understand their options and what the fees would be. When it comes to Medicaid fees, I can tell you it is a very specialized area of practice. What might you expect to pay? You know, really depends on what your plan is. But it is, I can tell you it's generally more than what a typical estate plan is. You could be looking at, you know, what does a facility charge in a month or 2 months. But on the other hand, what that allows is the state to pay for care for the rest of life, and that can protect hundreds of thousands of dollars. And so generally the benefit is well worth it. All right, so thank you all so much for being here today and to listening. I hope you got something out of it. I hope you can share that with other people. Any more questions, just feel free to reach out to us at ELG Estate Planning, and stay safe and take care of each other. Thanks so much.